are criminalized. So that is one aspect. Then also certain provisions related to cross-dressing and Section 399, I believe, of Penal Code that has certain it also criminalized somebody is presenting in as that in a different attire or so forth. So very easily a transgender person can be prosecuted under these particular provisions of the Penal Code. Now that is the criminal law aspect of it. So in nutshell, gay, lesbian, bisexual, transgender people can be charged by the existing provisions of the Penal Code. Now, the second aspect of this is actually the human rights angle of it. So basically the fundamental rights angle of it. Now, we do have a provision or equality provisions or equality before the law, and the Article 12 of the Constitution specifies number of different groups. Sometimes we use the terminology that discriminatory grounds, or sometimes we use the terminology certain minority groups. Either way, the LGBT group is not included explicitly in the Article 12 of the Constitution. So there could be arguments for and against that are be included as a group whose right to equality be protected. So Article 12, actually, the good thing about Article 12 is it also recognizes other groups. So it just it lists number of different groups or discriminatory grounds, disability, race, religion, and so forth, and also says other. So if you look at the international human rights jurisprudence, we can see the courts around the world, mainly the European Human Rights Court, has interpreted this term of other in the ICCPR includes LGBT community. And based on that, we can argue that the LGBT community's right to equality before law, non-discrimination is ensured by our Constitution. Some may argue otherwise, saying it is not specifically there. But I think there is a strong case in a modern democratic context that our rights are recognized under the Article 12 of the Constitution. Then there is a clash. One way, certain acts, the sexual acts of between same adults of same sex being criminalized. On the other hand, we have right to equality assured by the Constitution of this country. And then we have another provisions, Article 16, which actually basically allows the continuing enforcement of archaic laws. So basically, despite some of these laws fundamentally violates our fundamental rights principles, they can still be enforced. So as long as the only restriction that we have enforced through Article 12, right to equality provision, is that only it is applicable for the new laws, but the previous laws will continue to stay. And because of that, all the archaic oppressive laws, such as vagrancy ordinance or certain provisions of the Penal Code, will continue to be enforced. So in nutshell, that's where we are in terms of law when it comes to the LGBT community. And then we have to add one little thing, that is about the generic aspect of fairness and basically the generic aspect of the right of the citizens of this country. So as we know, there are a lot of questions about the right to equality before the law, not only for the LGBT community, but for a lot of people. So I'll stop in a moment. Sorry, I think we need to kind of unravel this just to initiate a discussion. So
yes, definitely.
Yeah. Okay, so the issues that are not necessarily being confronted by the LGBT community, but the issues that a lot of other people also face, generally in the hands of the police, how the police would treat an individual, and the aspect of the class, the power of individuals. So basically, you will see a lot of powers that individuals have because being belong to a particular class or a particular civil status. So those who have those civil status or belong to a particular class may not may have a lot of uh, may have the capacity to maneuver the police officers' decisions, and the police officers also would apply their discretion based on that sort of background, considering the background of the individual. So not only the police officers, but also a lot of public officers. So we have to bear in mind, it is not only the issues specifically, the legal the specific provisions of the law that actually harms the LGBT community, but also certain generic provisions of the law if you are not belong to the right, the right group or
Right.
the class. So we have to bear that in mind as well. For example, very briefly, I mean, I am, as a member of the LGBT community, I have the education qualification and I'm a lawyer and I have that civil power and I'm an artist and so forth. So I think, well, as far as I can remember, I have never been, even in Sri Lanka, I can't remember of being discriminated against more than handful events. But that is not the case for somebody who is not, who doesn't have that sort of background.
Right. Okay. Thank you so much for that extremely illuminating introduction to the legal aspect of the community in our country. So, I think you also mentioned when speaking about these laws, we have quite a bit of contradictions and quite a bit of vagueness in our constitution itself. I remember from watching other programs, there are certain phrases like against the order of nature, which are pretty vague references which seem to be used in order to exploit this law against a particular community, in this case the LGBTQ community. Is there anything that you would like to explain on this part?
Yes, actually. So I think this whole these laws have a history of couple of thousand years. It comes from the Old Testament, the Jewish, the Bible, and then followed by the New Testament, and then it was also certain provisions being adopted by the Quran as well. So all are Judeo-Christian religions, or sometimes we call them. I just lost the term. Anyway, so they have the same source, the idea of one God, and
Right.
there are certain acts that are against the will of the God. And so what happened is, because of that archaic historical roots are not very clear, the law also ended up being very unclear. But I guess when so the first instance of this particular law being codified could be found in the 16th century. I think it is by Henry the Eighth in England, and by enacting Buggery Act, and then followed by some other laws introduced in the British Empire, and we inherited those laws. So yes, there are a lot of contradictions and lack of clarity. And I think I have to mention that, perhaps I may not get a chance to mention that another time. This whole idea, this law actually being introduced, I think, the law is based on this idea that sex is only for reproduction purposes. So anything other than for reproduction purposes can't be natural. So if in that case, I think, as you know, that there are some clergy in African countries are advocating against the use of condom, because use of condom could be also unnatural. And and I think it's below this whole idea, this law is actually based on the idea of sex is not for any other purpose than the reproduction. So procreation, in the sense, for the pleasure, is not acceptable under this law. And because of that, actually, the term that you have applied, offense against order of nature, could be applied to both homosexual and heterosexual people, if you technically apply this particular term. In fact, apparently there are some instances, not now, not recently, but probably around early 19th century and early 20th century and before, this particular law has been applied against heterosexual couples as well, who have been engaged, who have been performing sex which is not vaginal for the purpose of reproduction. So it is not a law, as far as I can concern, it is not a law only that applies to same-sex couples. But in practice, this law has been mostly used, even to date, in a number of different countries, including Sri Lanka, against just to charge people of same sex having sex if they were found to have sex by the authorities. Now, but if we try to find a clarity for the purpose of criminal law, I would say, so the words that are floating around, one of the words is buggery. The buggery, that word is no longer used, although it was originally introduced in England in the 16th century. Now what we have is act against the order of nature and gross indecency, and those are the two terms that have been applied. And when we separate those two terms, it is a bit difficult actually to pinpoint what does it really mean. But I would rather have it as it is until they arrest me or somebody else, so we can argue in the court, well, hey, that there is nothing unnatural about that. But unfortunately, that was not argued in the case Galabada Piyagalage Sanat case, which is 2009 reported case. Unfortunately, that was not argued. The counsel did not, or the accused did not challenge the idea what is order of nature and what is gross indecency. And the court actually had the court or the Attorney General actually had the free reign of interpreting that without any objection from the accused, and they ended up interpreting oral sex as an act of gross indecency. Now, this is not even anal sex between two men; it is oral sex between two men. So then comes the question: would it be applied to heterosexual couples? We don't know. And there is another question, actually. That particular act in this particular case was, it occurred in public space. It occurred in a vehicle parked in a public space in Colombo. So, well, it could be gross indecency, if any sort of sexual act between any persons, if it happens in a public space. But what if this happened in private space? Do we have right to privacy? No, well, I wouldn't say no. It is not explicitly mentioned in our constitution, but there have been interpretation by courts in a number of different instances, including Sunday Times case, that our constitution does recognize right to privacy. If that's so, do we mean that court will have to balance, although Article 16 is there, does it mean that court will have to balance right to privacy and this Section 365A gross indecency? So those are the questions open for us. So yes, there is a lot of confusion, there is a lot of vagueness, but I think that Galabada Sanat case was an unfortunate incident where the councils didn't challenge the elements, the physical element and the mental element of the crime, and so we are left with the court interpretation that oral sex between two men is a criminal act in public. So I will leave it there to explore more later.
Okay. So, like you mentioned in that previous case, now you said the accused didn't challenge the definition from the court as to what is against the order of nature. So, which leads me to my next question. How aware do you think the community is about these discrepancies in the law and their rights, and what the community itself can do in a legal context? So, if they are charged, do you think everyone is aware of what they can say or do in order to challenge the court's verdict?
Now, before talking about the community, we have to talk about the legal practitioners and to the extent of even judiciary.
Right.
I think what we have to understand is this country, the judiciary, well, a lot of instances has been very backward, but there were a lot of instances that it has been very forward as well when it comes to, fundamental rights, certain aspect of fundamental rights and so forth. Very forward, very progressive, and we are cited by international jurists. And in some cases, that's how progressive we are. So I think if our judiciary has been progressive on, for example, public trust doctrine, why can't it be progressive when it comes to criminal law as well? And despite of the existence of Article 16, can't we follow the Indian pathway of recognizing right to privacy over the criminal offense of consensual sex between two adults of same sex? So I think there is a big issue of the lack of awareness amongst practitioners, even and including the members of the judiciary. So I think what the practitioners should do is they should challenge the construct of the offense, the content of the offense. What does it really mean? And does it mean, just ask those questions? What about privacy? What about similar acts between heterosexual people? And what is exactly unnatural offense? What do we mean by gross indecency? Shouldn't gross indecency be an act committed in public, not in private? Because how can you really commit an act of gross indecency when there is no third person watching you from objective or subjective point of view to interpret that act is indecent? So there were a lot of questions to be asked, and those questions need to be asked by practitioners before the community start questioning these things. But I think for the community, what is most important thing is by learning the element of actus reus of the criminal act, they're not going to stop having sex. And as far as the community concerned, the act between any kind of sexual act between two consenting adults is natural. And whether it is a criminal offense or not, the act will continue in countries like Sri Lanka, where there is relative safety net, and unlike Iran or Afghanistan, where still death penalty is applied. I can't remember about Afghanistan, but Iran is, yes. So I think what we really have to educate, what the community really, I don't think there is, I think it is okay it is better for the community to be aware of the content of these offenses and what does it mean by that, and what is the act, and what is what is not. But I think what is most important is the community to be aware of their general rights, their rights in the criminal procedure. When can they be arrested, and what are the requirements that a police officer should fulfill when it comes to arrest, and what are their rights at the point of arrest to the point of remand prison, and then taken into to a magistrate and so forth. And they should be aware of their generic rights as an accused person or as a suspect more than anything else, and then only they can really challenge it. And also they should be supported. They should actually build those support networks of legal practitioners. When there is a problem, they can actually get involved. And most of the time, if you manage to get the legal practitioners involved in the very early stage of these sort of incidents, before it goes anywhere else, the police would actually give up, because it is very difficult for them to continue a case unless they have very, very clear evidence. But as we know, most of the times what happens is mostly gay men are arrested under the vagrancy ordinance, and not necessarily under the penal code. And then they use the sexual orientation of the individuals to harass them, and sometimes even take bribe, and just to kind of show their numbers up. talking about numbers, I think in 2018 police data shows that there have been 750 cases of unnatural offences under Section 365, and 39 cases have been investigated. What does it mean? That vast majority of the cases have not been investigated. So what could have happened is most likely they would have been charged either charged under the vagrancy ordinance and force them to force them to plead guilty and let them go after they paid a fine, or police would have ended up, receiving certain favors in return of release. We don't know exactly, but the data shows a very huge differences, the gap between the number of offenses and number of investigations. So, and I think there is another important thing that the community should do, apart from being educated about their general rights and building support networks. That is actually initiating a debate about this construct of the offense. And also basically re-articulating the way that I am doing and way that you are doing. What does it really mean? Do we really have to adopt an archaic provision to interpret a modern a law in the modern time? And so are we going to use the way that the cases that involves Buggery Act of the UK, or the Offences Against Sexual Offences Act, and to interpret our penal code in relation to consensual sex between adults? So these are the questions that we have to ask. Actually, I think we have not been loud enough to be heard by the legal practitioners and judiciary in this regard. Yes, there have been some attempts, but it is mainly those attempts were mainly centered around number of handful of organizations and not by the community at large. And we haven't seen more than 2 public protests in this country conducted by the LGBT community, and that was also 2-3 years ago, and around the same incident, and being called butterflies by the former president. But there have been so many other incidents happened since and also before, but actually nobody came forward to protest. And I think this is really important, that we have to be visible. We have to claim our existence, unfortunately, not before claiming our rights and right to exist. And we have to actually position this debate on the platform of modern democracy. What is modern democracy, and should this particular type of interpretation of law be tolerated in a modern democracy?
Right. Yes, I remember even last year we had a few cases. I think we had several high profile cases where they were even forced anal examinations. I remember there was a huge outcry on social media about it. So coming to your point where you said in 2018 we had 700 plus cases, out of which 39 were investigated, we can see that there is a much greater tendency from law enforcement to charge them than to actually investigate the case in terms of the legal practitioners. So when it comes to law enforcement, do you think that there is some discrimination going on in law enforcement when it comes to charging them? Do you believe that law enforcement is aware of the discrepancies and the vagueness of the laws they cite when they charge these individuals, or that they are aware and this is just a social mindset coming out through the use of these laws?
Look, I think they are aware, because yes, we have to have when it comes to the definition of the offense from the point of view of legal practitioners or academics or journalists like yourself, we have a very complex debate to continue, basically arguing what does it really mean. But I think from the police officers or the law enforcement officers' point of view, it is clear, at least for now, it is clear because of the court decision, that oral sex between men is against, it's a criminal offense, and also possibly anal sex. If it's oral sex is a criminal offense, anal sex too. So that has been cleared out. So I think and also I have a feeling, I don't know whether anybody has conducted any proper research in terms of interviewing these law enforcement officers, but I think that idea is clear, that they should know on what occasions they can arrest. But the other issue is actually they also end up arresting a lot of street workers, and some of them could be sex workers. Some of them could be actually from the LGBT community, mainly either maybe transgender or gay community. It could be. There are, like in any community, in our community also, we have people engaging in sex and in sex work. So, and that sort of people can be arrested for the simple reason of being engaged in sex work. As we know, prostitution is not an offense in the country, but it is an offense only if it is we attempt to procure in public spaces, and running a brothel. And so when it comes to that area, perhaps the law enforcement officers are not very clear about that, particularly in terms of transgender status, and even to the point of cross-dressing, for a party or something. And I don't think they are aware what are the boundaries of the offense. And the issue is, however, though, technically they don't have a discretion, I think, because our penal code very clearly say these are the offenses and you should arrest them. And when it comes to those very clear offenses, such as oral sex or anal sex, our penal code is very, it is not our penal code is clear, but I think technically the police officers don't have discretion not to arrest. But practically, that is not the case. As I told you, the police, the officers' decisions are made based on a number of different grounds, and they apply their discretion based on a number of different grounds, including the class and social status of that particular individual. Then I think second thing is about the rights. So as you can see that I have been always continuing this discussion on two different areas. One is the aspect of criminalization, the other one is the aspect of fundamental rights. So when it comes to fundamental rights, I don't think the police officers or even any public officers are aware of the rights of the LGBT community. Because it has been specifically spelled out in the Constitution, and because the legal practitioners, including myself, haven't gone far to argue that, apart from in tiny little few academic papers, which is not adequate, I think. And also the community at large, LGBT community, haven't gone far to argue that we have this protection under the Article 12 of the Constitution. And because of that, I think the law enforcement agencies do not have a clear idea that LGBT people have equal rights before the law. And also mainly, and their obligation to respect privacy. And they would know whether any person was engaged in unnatural sex only if they break the barrier of privacy. So, but the privacy is there. So how would you, just simply because you suspect or you've been notified, you would go and just break that barrier of privacy? And what occasion can you do that? And the fact that although it is not explicitly mentioned, our law recognizes right to privacy. And that aspect perhaps not been, and I don't think the police officers are aware of that aspect. And then finally, the generic aspect that we discussed earlier, what are the individual's rights? As we know, vast majority of people who have been tortured in the police custody are not necessarily LGBT people. Could be those who have been suspected of some petty crimes or even major crimes. And vast majority of people who have been arrested by not necessarily LGBT people. Some ordinary women, some people with disabilities, some people who are engaged in street works or as a beggar or as a sex worker. And so what we see is there is that lack of, or rather the total ignorance and lack of respect to the individual's fundamental rights from the point, from the part of the side of the law enforcement agencies. So that is a big issue. So I think it is, so we had to look at, we had to, in terms of answering your question, we had to look at all these three perspectives. One, the criminal, the offense perspective. Two, the fundamental rights perspective of LGBT rights, LGBT people. And three, fundamental rights perspective of everybody and all fundamental rights, including right to have a right not to be arrested arbitrarily, and right to have a fair trial, and so forth.
Right. So, speaking about all these perspectives, what I can see is that there are certain reasons, like you mentioned, class and society as well, that essentially are holding back people from performing and talking about this issue to the full potential. So, in such a context of society, do you think just a legal reform can work towards solving this problem, or will it be ignored, or will the social mindset of the people involved be too much of a barrier, even with a legal reform in the works?
I think it has to happen in a number of different platforms. So the legal reforms are absolutely essential, and we have seen in a lot of countries, even including Sri Lanka, how important it is to have legal reforms when it comes to ensuring fairness, justice, equality for the citizens. And so I think it is absolutely important to have that, introduce those legal reforms. If we are talking about very clearly repealing of Section 365 A and 365, and also 399, and then repealing in the sense repealing to ensure, because there are some other provisions as well, so, issues related to child abuse and things like that, bestiality and things like that, but repealing or amending those provisions to ensure that sex between two or many adults, consenting adults, should not be criminalized. So that is the most important thing. Sex between consenting adults should not be criminalized. The second aspect of the law is being very specific when it comes to fundamental rights. And not only that, also repealing Article 16, I think. So that would be something important, not only for the equality for LGBT community, but also for women, people with disabilities, and all sort of people, older people, and those who have certain mental health illnesses and so forth. It would be useful for anybody. Right. Now let's actually look at the other options. So I think, so the legal aspect is one, but there could be certain things that we can do with or without legal reforms, and those are the policy initiatives. I think, a lot of times we can get a lot of things done by policy reforms without having to get any particular act passed by the parliament. But I think, of course, you can't compare those to the impact or the influence of those two aspects of the initiatives. But policy initiatives are still possible for forward-thinking public officers to be taken. And it is very easy. It is basically issuing of circulars by a minister or secretary to a minister or departmental head or so forth. And one of the examples is actually the circular issued by the Ministry of Health in relation to the change of the documents of transgender people. And when they are going through a gender reassignment, and they can amend their, they change their name in the document to reflect their assigned gender. Reassigned gender. So that is actually done. There is no law passed by Parliament yet, but that is currently being done by simple policy initiatives of the government, of the Department of Health, Ministry of Health. So I think there could be a lot of things being done. And there were some discussions with the Department of Examination, between the Department of Examination and Human Rights Commission. I don't know how far it has gone, but this is before the changes of the commissioners, and in order to change the details of examination certificates. And there could be a lot of things done without having to change the law. And you know, a lot of issues happen in educational settings. You know, for example, in the law faculty, if somebody, one of our students, come out tomorrow and say, well, I'm going to go through a you know, the gender reassignment process, and we don't have a proper student toilet to be allocated for that particular person, and then, you know, we don't have proper procedures, we don't know where to start. And I think that those are the important things that we should be mindful when, and those things could be done without having to change the law. And there could be a number of different guidelines issued by government department, how to treat, you know, how to treat an employee who is from LGBT community, how to treat, how to ensure equality for LGBT customers, and so forth. And these are the things that done in a lot of Western democracies, whether or not they have a particular legal protection. Now, the third thing is actually the education of everybody, not only the LGBT community, but also the police officers, members of the judiciary, any officers of public sector in general, who are mainly, you know, who are actually in the frontline services, such as health officers, you know, officers who are engaged in public health, and also officers who may, you know, run certain services and have frequent contact with general public. And then NGOs and other organizations, community organizations, who may have something to do with the LGBT community directly or indirectly. And then also private sector. I think in Sri Lanka, the private sector is far more progressive than, in some aspects, private sector in the sense, you know, large multinational companies such as banks, and multinational consumer goods companies. I have noticed that some of them are far more progressive than the public sector, which is not the case in other countries, sometimes in Western democracies. Because in Western democracies, the public sector is much more progressive. They walk the talk because of a number of reasons, you know, public sector employment conditions and things like that. But here, actually, those who are walking the talks are not a lot, but a few multinational companies. So it is really important that we have certain education initiatives targeted at all the layers of the society, and not necessarily only for the equality of LGBT community, not only for the equity of LGBT community, and it is for everybody, and to create a culture of inclusion. So my last point is that we have to create that, we have to foster that culture of inclusion in all sort of organizational levels, from the school to the universities, from hospitals to police stations, and from you know, small size enterprises to large multinational organizations. So I think that is the most important thing, and that wouldn't come simply because of business reasons. So what is happening in Western countries is there are two things. One is the Western private enterprises as well as government enterprises understood that you had to be inclusive, you had to promote diversity in order to harness you know, in order to basically access a diverse and talented workforce, and also access their clientele. But we don't have that understanding here. And also the other thing is, in Western countries, they also wanted to treat everybody equally, because that is the democratic norm of those countries. And we also don't have that, unfortunately. So I think what is really important is that while we are doing all these reforms, either legal reforms or policy reforms or education initiatives, we have to actually look for various ways to foster that inclusive culture in all layers of the society.
Right. Okay. So following up on that, if we are looking at just the legal side of things, how do you think a reform could be best suggested and implemented, through the policies or through some other initiative?
I think, first of all, it should there should be certain changes, and from the point of view of legislation. So, I think in terms of introducing reforms, there have to be legal reforms, and there have to be policy reforms. Usually what happens is actually those policy reforms come after legal reforms. So the legal reforms are introduced first, and the law would say, that everybody should be treated equally, and then the agencies have to introduce policies. How we are going to make sure that how we are going to ensure equality? By ensuring that our recruitment process is equal, and recruitment process is fair, and then ensuring that our clients are treated equally regardless of their background, and so forth. Those are the kind of the second round of reforms comes after the legislation reforms, as policy reforms. But that is a usual cycle, but I think it doesn't have to be like that. And certain agencies can take initiatives, certain public sector agencies can take initiatives and actually introduce policy level reforms rather than waiting for the legislative reforms. This is
Right.
my proposal. And then I think most important thing is the constitutional reforms, because I think that's what we have to really get right. And in terms of reforms, I think it could. I mean, it is ideal to see an amendment to the Article 12, and introduction of the LGBT as a discriminatory ground. If not, at least the Supreme Court one day pronouncing that very clearly that LGBT community is included under and the Article 12. But I think we have certain precedents, and we have faith, because at one stage in, I think, Durham Manual case, HIV status has been recognized under Article 12. So if HIV status can be recognized under Article 12, which is not specifically mentioned, our Supreme Court wouldn't hesitate, I believe, to recognize LGBT status as well.
Right.
We have not been mentioning the intersex, but we can mention that as well. And that is a very silent community in Sri Lanka, although it's a very loud community in other countries, and some
Right.
of them do not want to be yoked into LGBT group, and they want to have independent advocacy strategy. So that's why I'm not kind of talking about and
Right.
then you will hear about QQ and so forth. And I haven't gone that far, because I thought it is better to, for the time being, focus on the law, because
Yes.
and refer to the international instruments. Now, I think I partially answered your question. If you ask me what is missing from my answer, I can continue.
So, what I would like to know is, now, policy level reform suggestion is honestly a very practical answer, and I think more implementable than most of the suggestions that are on hold at the moment. But when it comes to implementation, how would you suggest we go about this?
Now, I think I used to work in the public sector in Australia New South Wales government for a long time, for about, I think, nine years. So I probably now going to rattle out the strategy that we used to apply, and it is typical public office, public servant or public officer is talking. But I think it worked. That's what I have seen. It worked in public agencies that I have worked, and I was mostly doing work related to equity and diversity inclusion in workforce, as well as in customer services. And what I have found, the way that it is going to implement is always we have to have a backup of backing of strong equal right
Right.
legislation.
Right.
And we can just show the book and say, well, this is the law, whether you like it or not, you have to do this.
Right.
That is a last resort, by the way. But I think before going into the last resort, we can actually talk about the benefits of diversity and inclusion, and the benefits. And you might have heard that, you know, organizations, including organization in Sri Lanka, has put a dollar figure or rupee figure to calculate the losses to the economy because of our discriminatory practices. So that is the other part of it. So while we have the law in one hand to, you know, as a weapon, I think we have another carrot in the other hand, which is actually to show there are so much benefits,
Yes.
and your agency is going to be very productive by making sure that the LGBT people are treated equally. And so I think those are the two different approaches that we can take. And both approaches actually could be based on policy reforms in agency level rather than national level. It could be national level as well. Then I think we have to talk about even briefly in terms of criminal law, in terms of reforms. Now, I think when it comes to uh, criminal law reforms, I think there are probably, I would say, two, maybe three ways of doing that. One is the front door way. The front door fight is basically you go and fight and, you know, protest, and you just basically challenge a number of different cases. And you might have heard of the Rooney in Tasmania in Australia, because Tasmania is the last state of Australia to decriminalize homosexuality, as you know, homosexual acts. And Rooney actually, and police actually basically gave up arresting people because, you know, it's never done in other states. Why should we do that? And the state government was conservative and they didn't bother amending the law. And Rooney and his partner continuously go and appeal police stations saying, well, you know, me and my partner had sex. Why don't you arrest us? And the police keep saying, just go home. Don't you have anything important to do?
Right.
And it came to the point that Tasmania has to decriminalize because it became such a, you know, issue, and, you know, they were getting so much media cover and things like that. And then the backdoor way is what recently been attempted under the former president Maitripala's government, and, you know, some quiet, you know, some little amendments to the constitution, and basically hidden with so many other files, and, you know, and other amendments to the penal code and number of other laws, and presented. If it was not, I mean, I think by chance we lost the opportunity. That's what I feel, you know. I mean, we know these politicians really don't, you know, read all these documents very clearly. I don't think they have very clear idea about what laws they have passed, and most of them don't have the capacity to read those legal documents. And usually, you know, things are based on the party line, and that law could have been amended, and homosexual acts could have been decriminalized, except for the fact that president noticed, perhaps because someone else noticed that and warned president, the former president. And you know, the backdoor ways work, and it could work, but I personally don't prefer that, because I think that doesn't have value, and that doesn't have the
Yes.
ownership of the community. And yeah, so the third thing is revolution, and revolution in the sense of constitutional revolution, and like what happened in South Africa. You know, South Africa had the most progressive equality rights provisions in their constitution. And perhaps if we come up with that sort of revolutionized new approach, I think that probably eliminates the requirement to amend the criminal law, or you know, coming up with a lot of policies, because the fundamental, the framework, the constitutional framework is so progressive, and it won't give any space to any of oppressive laws to exist.
Okay, so the last question before we wrap up is we spoke a lot about how legal reforms can be implemented and how legal practitioners and policymakers can help in bringing about this change. But for members of the community who are not versed in the legal side of things, like me, and allies who are also not versed in the legal side of things, what can members do to bring about this change when we talk about members of the community and allies as well?
Yes, I think there are a lot of things to be done, and I think the basic aspect of what we are doing now is we both have been very political, okay, and while we are talking about law, we both have been very political. I think what we need to really understand is the community has to be politically vocal and politically aware and politically active if the community wants some dignity, some respect and equality. And what is happening is, I think we have been always in the wrong time of the process of evolution. And if I try to explain what I said, in 1960s and 70s, in Western countries, the LGBT community started coming out and
Yes.
celebrating their sexual orientation. And by 80s, they were fighting with the police. And by 90s, they got the law decriminalized, and followed by their right to equality being admitted or established by constitutional reforms or something. And by late to by in the last couple of years, going as far as being recognized, the same-sex marriages being recognized. But I think what if you look at the process, they have been very political to start with, and they have been fiercely fighting the authorities to demanding their rights. And also they were actually not only politically engaged, they were socially engaged as well. And there were a lot of social spaces for them to gather, and they were making those spaces. And they were gradually taking over certain parts of the cities, and the LGBT community from the suburbs and rural areas were coming to those centers and building communities. And those communities and spaces became the strongholds and the bastions of the fight. But by the time we started that discussion, unfortunately, we have gone virtual, and the way that we meet, sexual partners or friends is through the internet, and we have become very virtual creatures. And also, the pandemic has added more complexities to that, and so we are a very unfortunate generation in the sense, when we look at generation of countries. That Western countries have gone through that evolution, but we missed that out. And now we have to fight this battle on virtual space. And also the thing is, a lot of people actually are okay without their rights. They think they're okay. That is very unfortunate thing, because you can find your sexual partners through virtual spaces, and then why would we bother? And and then the second thing also that they have, the LGBT community has actually was 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 covered or immersed in this whole nationalistic discourse, of they're trying to recognize their national identity. That is fine. I mean, we can talk about that in another time, the problems of, nationalizing the nationalistic ideas. But if you talk, they started to take over their racial or identities. Their sexual orientation identity is suppressed by the racial and religious identities. And what happened is the LGBT community is also, like any part of the community, there are racist people, there are religious extremists, there are people who actually reject the importance of human rights and fundamental rights. And there are people who basically think they think that their rights should be recognized only by their preferred government, not by another government or another political movement.
Right.
So this is, and I think that if you look at the reason for all these issues is that we have not been political from in the sense with a very good understanding of our rights and our dignity. And I think that is the most important thing that the community should do. How are we going to do that? I think we should start claiming spaces like the way that other communities have done. And this is not a very, I'm not talking about in the Western sense. I mean, if you look at the Katoi community in Thailand, which is an ancient culture of Katoi culture from a Theravada Buddhist country, and then Hijra community in India, again, an ancient culture from a Hindu background, and sometimes also in Islam background, because the Hijra community exists in Bangladesh and Pakistan as well. We are not talking necessarily about some Western notion of identity politics. We are talking about, in certain countries, they have created space and there have been traditions, and we unfortunately don't have those traditions. We haven't fostered them, and we haven't created those spaces. And I think, and then the other, the paradox of that is we live in a country predominantly Buddhists and Hindus, and Christians and Judeo-Christian religions are minority religions, and Buddhist and Hindu religions don't necessarily have no authority to condemn homosexuality or LGBTI rights. So that is a paradox. So I think what we have to do is and look at all the ways of claiming our dignity. Sometimes we might have to even use the Hindu and Buddhist the religious values to claim our dignity. Sometimes we have to use Western democratic values. Sometimes we have to use our own fundamental rights. And either way, we have to publicly claim our dignity and equal rights. And practically, how we're going to do that, we have to create those spaces. We have to voice our concerns and show it to the public in a very, very diplomatic and careful way. And we have to do it very careful, because we don't want to rock the boat, and we don't want to kind of create a huge public outcry against our rights, because at the moment we are living in an environment where human rights are very, very much welcomed or favored, and it is being seen as some Western conspiracy or something like that. So in a time like that, we have to take a step back. When we have a good environment to talk about that, we take a couple of steps forward, and we basically, I think, and try to engage in various cultural and art activities, as well as other recreational activities, to show to the existence of our community, and also to celebrate that. And I think I attempted that by doing frangipani film, and some other people have attempted that doing other things, and presenting their body that they are proud of, in photographs and things like that, in photo shoots and things like that, and sometimes songs and so forth. I think these, and then also I think the most important thing is that we have to basically win allies to our side, and not only our parents and friends, but also the other people who are working with us, who are learning with us, and who may hurt us, but we hate us, and still we have to try our best, rather than being confrontational, try to find ways of winning them. And we have to be good role models, particularly law students can be very good role models, as either a member of an of the LGBT community, or allies. And they're going to be the legal practitioners. They're going to take over one day significant part of the political power of this country, and they can be a good role model. And finally, I think the most important thing is we should not fight this battle alone. This battle has to be fought in multiple fronts with a lot of partners. And who are our partners? Actually, I think all minorities are partners. And of course, they may not welcome us. But I think we can at least start building some bridges with other minority groups, such as sex workers and people with disabilities, and just trying to engage with the discussion, saying, we may have different requirements and needs, and we may be physically and otherwise different, or our desires are different, but at the same time, we are fighting for equal rights. And if we get it right, for everybody, for one group, and everybody will be benefited. I think that is what we have to do, and I think this was very, very clearly done in other countries. And for example, a lot of, when I was working in New South Wales government, we had a number of different programs for people with disabilities and people from LGBT community. And in Australia, there is a significant Indigenous community, from Indigenous community, and so forth. And then I think by the time I was leaving the sector, I could see that whole divided approach to equality has changed, and everybody were coming together. And what I'm proposing is diversity advisory councils for agencies can have members from different communities, for example, LGBT community and people with disabilities and older citizens who are still either in the workforce or not, but still they are there. And then other minorities, such as even racial and ethnic minorities, they ensure the representation of all the groups who have lesser strong voice in the community at large. So I think we have to work with everybody in order to achieve equality for us.
Right. So with that, unfortunately, our time has come to an end. I'm genuinely sad. I would love to continue this conversation for much longer, but it's already 7 and I think we have to wrap up. But thank you so much for such an insightful conversation. I learned a lot, and I'm sure our audience did as well. There were so many new perspectives, so many new insights, and it's wonderful to have you on board. I would also like to thank the Rotaract Club of Law Faculty for facilitating these conversations. These topics should be talked about much more. And thank you guys for hosting us and making this possible. Dr. Visakesa, thank you so much once again for this insightful conversation. And with that, I bid you all a good evening.
I just want to thank the Rotaract Club as well. And this is really, really interesting step taken towards in multiple levels. So I hope that you will continue these sort of really interesting conversations. I look forward to engage in more conversations. Thank you.